and in the provision of care when a patient presents at the healthcare facility. Some examples of these things, you know, the transmittal, storage, and processing of forensic evidence during the SANE exam. There were some differences in the methods. There were also some differences in where these kits were ending up, who was taking them where. Some hospitals, as you'll see a little bit later when you see the results of our survey, some hospital SANE programs reported holding on to those kits, or, for example, if the police did not come to pick up the kit and the SANE folks didn't want to destroy the kit, it would be in storage somewhere at the hospital. For the composition of the medical forensic collection kits, these kits were supplied by various different companies and purchased by the hospitals themselves, so the composition was not uniform. And there were some issues with the order of how these things were to be collected according to what was provided to hospitals from the crime lab. And we'll get into that in a little bit. And last but definitely not least, and probably most important, was the provision of care when the patient presented at the healthcare facility, including options for patients who did not wish to make a report to law enforcement. We were getting reports from all kinds of folks out in the field, from advocates, from SANE nurses, from victims themselves, that the care that they received and actually what happened to their kits, the evidence that is that was collected after a SANE exam, could differ and could vary widely throughout the state. So that when a patient came to one facility, we wouldn't be sure, like if I came to a facility and presented and I wanted some care and I wanted to have the SANE exam, but I wasn't sure if I wanted to report to the police, it wasn't clear what was being explained to me about what was going to happen to that kit and the evidence that was collected. Some hospitals were holding on to them. Some hospitals had agreements with their local law enforcement that they would forward it to them in kind of a quote-unquote anonymous kit fashion. And some other things were happening. So we knew that there was inconsistency in what was being explained to victims and how their kits were being handled. There was also inconsistency in billing practices. Hospitals can bill for the SANE exam. They are not to bill victims directly now, but there were all kinds of issues in terms of what was being included in the bill. For example, if I was sexually assaulted and my arm was broken during the sexual assault, I might need an MRI or a CAT scan or something like that for the broken arm. Question becomes, is that part of the SANE exam because it happened during the sexual assault, or is that not part of the SANE exam, and what needs to get billed for? Well, whatever. Okay, there people are laughing at me about an MRI, but okay, let's just say. I think everybody knows what I'm talking about. X-ray. I really didn't go to medical school. How's that? I feel like I deserve an MRI if my arm is broken, but maybe that's because I'm special. So anyway, these things that were happening throughout the state were already being discussed. They had been brought to the attention of the Department of Justice through the good people at WCASA, through other advocates, through the SANE nurses and Jackie Kalari Robinson. So we had already been kind of cogitating on those things and thinking about what to do when this particular legislation came along and made the Department of Justice responsible for creating administrative rules around this new law that they passed. Want to talk about the creation of the AG SART?
In late 2012, J.B. Van Hollen was the Attorney General, and we realized that we needed a statewide group to be able to handle the issues that Audrey just talked about. And I went in and I talked to him and I said, what do you think about putting together a statewide sexual assault response team? And almost before I could get the question out of my mouth, he said yes. And one of the things that we recognized very, very early on is that we needed to have a multidisciplinary team put together. We needed to have advocates and law enforcement and prosecutors and medical personnel and people from the crime lab, because that was the way that we were going to absolutely have the best outcomes. So Attorney General Van Hollen convened this group. We started in December of 2012, and we have called this group the Attorney General's Sexual Assault Response Team, or AG SART. We appointed members, or the Attorney General appointed members that represented the 4 systems that we felt were most responsible for responding to sexual assault victims: the medical folks, community-based advocacy, law enforcement, prosecutors. I'd also add we had a few people who I would call policymakers. Also, we were very, very lucky to have the director of the state crime labs as part of this group. It was Kevin Jones at the time. Jana Champion, who is the head of the crime lab right now, is part of the group, as is Dan Campbell, and Nikki Casper, and they have shed so much light on this group for all of us. It's been just wonderful to have them included. This is just a composition of the AG SART. We often have many, many visitors at our meetings. All of our meetings are open. Anyone is allowed to come. We comply with the open meetings law. Our next meeting, in fact, is July 14th, and it will be at the State Bar starting at 9 o'clock in the morning. The first thing that we began by doing was we needed to identify common ground, and we had to build on that. And we decided that the most important thing that we were going to do, and we were going to keep our eye on, our desire to support victims of sexual violence, and we were going to hold offenders accountable.
We didn't want to start with nothing because we knew that so much work had been done already in the state, so much good work in the realm of SART and in the realm of sexual assault, different various protocols. So we did utilize the existing protocols and identify them as starting points, including the Wisconsin SART protocol, the SASP advocacy protocol, the Wisconsin IAFN protocol. We had various law enforcement protocols, and we also had, a number of states. We are not alone in facing the issue of having a large number of untested kits in our state. It's been in the news. It's been all over the place. In the United States, we share this problem in common with many other locations. So we decided to also take a look at what national protocols we're developing, for example, in Virginia and some of these other places throughout the country. So we did identify those. All right, new protocol when the patient presents for a SANE exam. So the first thing that we really worked on in the AG SART was after we identified our common ground, after we identified the protocols and the various resources that we could use, we convened the group and decided that the first thing we would talk about was a new protocol when a patient presents for a SANE exam. Our goal here was to create a consistent patient experience for victims who appear at a healthcare facility. We developed a patient algorithm that will be used by all SANE nurses. I know the word algorithm, probably many of you have already run out of the door because you were promised there would be no math and no algebra or anything like that, but unfortunately I am reliably told that algorithm is a term used by our medical friends to describe sort of what I would call a flow chart or a checklist or a way that things are supposed to proceed. But, when in Rome, so we referred to it as patient algorithm that will be used by all SANE nurses. We also developed a form that would explain the options for victims who present for a SANE exam.
I just want to say that the whole idea behind this is that what we wanted to do at the time of the SANE exam was to give patients two things: information and options. And this was the way we decided to do it.
So now the remaining folks who have fled out the door, now that you've seen this algorithm, a patient seeks care, but we're gonna soldier on. This is sort of a depiction of the three basic options that we articulated for victims when they come and seek care. Option one, you see there that the victim arrives at the medical care facility, they receive a medical forensic exam, but this is your victim who knows that they do not want to make a law enforcement report and they don't want kit collection. They just want their medical care. So option one is pretty clear. It's the victim who knows what they want, and they don't want to be involved in law enforcement, and they don't want the evidence collected, so there is no test of any kit because no kit is collected. Option number two is the other end of the spectrum, in which the victim appears, wants a medical forensic exam, does want to make a law enforcement report. There is a SANE exam, there is collection of the kit. The victim decides on full participation, and that kit will be tested, forwarded for testing. Option number three, this is the one that we spent the most time obviously developing. This is a victim who comes to a medical care facility, wants a medical forensic exam, does want collection of the kit, but is unsure whether he or she wants to report this to law enforcement. So the question became, what do we do at that point with a victim who is unsure? And as Jill said, you know, our most important thing really is to get as much information to that victim as possible, taking into consideration, of course, that the victim has been through an incredibly traumatic event, and presenting here at the hospital is a continuation of the event, and it's going to be difficult in many cases. So we wanted to present as clear information as possible, and of course we wanted to involve advocacy and all the folks that can help the victim at this point. So we had some debate over what time period. The first thing we decided on was that there should be this wait period. In other words, so we thought this would be the best option, so that the victim could have time to process, could have time to think about things, and the victim was not foreclosed just by walking away from the healthcare facility or being unsure that the kit wouldn't be destroyed at this point. So we started out with a waiting period of, I think, 30 days was the first place we were at, and some of us wanted 30 days and some of us wanted forever and ever, amen. So we really debated a lot. We went around and around, and we decided to go with a waiting period that reflects the majority of the statute of limitations that exist for sexual assault crimes in the state of Wisconsin. It's true that there are some crimes for which the statute is longer, you know, forever, and it's also the case that some are shorter. But the statute of limitations, and this may change, of course, because I understand there might be legislation pending or you know, that is being debated, I should say, as to extend the statute of limitations to 10 years for the majority of sexual assault crimes, and I think in that case we would revisit this. But at this point we arrived at 6 years, and it's actually going to be a wee bit less than 6 years, because of course if we have a victim who reports on the very last day of 6 years, it won't even get to the prosecutor by the time to make it under the statute of limitations. So we have to tweak that and fine-tune that a little bit, but in general concepts it's 6 years. Now during that 6 years, and at the hospital, the victim will be informed about these different options. If the victim decides not to report to law enforcement during that 6 years, or we don't hear further from the victim, then that kit would be destroyed. There's a little box right above where it says wait period 6 years, and I didn't talk about that, so I'll go back to it for a minute. The collection of the kit at the hospital, in the case of a victim who is unsure, that kit will be sent to the crime lab directly from the hospital. This is intended to avoid the situation in which the hospital has to store this evidence somewhere, which is not good for anybody. It's not good for the hospital. It's not good for the kit. It's not good for chain of custody issues should this case ever be able to go to trial. It's just not good all the way around. So the kit will be sent to the crime lab, and we'll talk a little bit about what happens once it gets to the crime lab. I just want to point out a few things. That first of all, the 6-year waiting period is the longest in the country that we've seen. Many jurisdictions have only 30 or 90 days, and some are leaving it up to local
municipalities to figure out how long they want it, so it's very different depending on where you are in a particular state. The second thing I want to just point out, because I've gotten a lot of questions about this, is that the reason that we are having the hospitals send the kit to the crime lab is because they are doing that just for the crime lab to hold on to them. If the hospitals gave the kit to law enforcement and you had a situation where you have a case where it's a case of sexual assault and you have DNA evidence and the perpetrator is unknown, because it's in law enforcement's hand under 975.405, law enforcement would have to send it to the crime lab for testing, instead of the hospital sending it to the crime lab to hold on to for a period of time.
So yeah, thanks. That's really, it's good to know. I think we have a question. Why is there nothing mentioned about volunteer advocates being contacted in the algorithm? Shouldn't this be done before the exam is started?
Yeah, that's a very, very good question. What we were really looking at here is what was happening as far as the kit in the hospital. We are doing lots and lots of training on this. We've been at the SART CCR training. We absolutely think that advocacy should be involved in every single step of this. It's just not part of this algorithm. It certainly has been part of our discussion all the way through, but it just simply wasn't part of this discussion because we were just focusing on what happens as far as the medical care and the kit in the hospital.
Yeah.
Hi, everyone. This is Ian Henderson from WCASA. And one thing to note, and Audrey talked about this earlier, that the SART protocol was part of the a document that informed the work of the committee. And certainly that document, as I'm sure many of you know, states that it's best practice that an advocate's contacted when a survivor presents at the hospital. And so we're that has not changed, and obviously this is really more about what options a victim is presented with regarding the forensic exam and regarding the rape kit. But as we'll see when we come to the consent form, which is coming next, there's obviously a role directly contemplated for advocates.
Right. Okay, yeah, we've got another question. Okay. Okay. This one down here?
Yep.
What happens when the victim wants a kit done but doesn't know if they want law enforcement involved, and the hospital takes the kit to the local law enforcement, and they then contact the victim for more information?
Right. I think when we get to the consent form, you'll see that should not happen. I think if we go along, you'll see that that's not one of the options.
Well, and where this breaks down is, the question is what happens when the victim wants a kit done but doesn't know if they want law enforcement involved. So right away we are on option 3 on your screens, and you can see that there will be a medical forensic exam. The kit will be collected as is contained in your question. However, where it breaks down is the hospital will not take the kit to the local law enforcement. Under this algorithm, under option 3, the hospital does not do that. The hospital sends the kit directly to the crime lab. Then there's this waiting period of 6 years. In that waiting period, if the victim decides no and there's no further contact, that kit is not tested and will ultimately be destroyed. If, however, the victim decides, let's say I'm the victim and a few weeks later I'm feeling better, my injuries are healing, I'm able to get some counseling, I'm just feeling like the trauma has died down a little bit and I'm able to make a good decision, and I want to say, okay, I think I'll make a report to law enforcement. I decide to make that law enforcement report. The law enforcement agency is contacted. I will have a number you'll see on the form coming up, and I'll know who to call. And the kit then, the law enforcement agency would then contact the crime lab, and their kit would be tested. Now, of course, that we may or may not be able to prosecute at that point. It really depends on whether how the police investigation is able to proceed and what kind of evidence we have. But of course, we could use the information for other purposes. I think it's going to get more clear when we look at the form here. So We are, now you're looking at the form that will be provided to victims who present to the medical care facility for a SANE exam after a sexual assault. We decided for a while this form was only going to go to victims who could not make up their mind or were undecided as to whether or not they wanted to report to law enforcement. But ultimately, we decided that the information in it was so valuable that we wanted every victim to have it when they came and presented to the healthcare facility. I want to talk about subpoint A, our starting point here.
Yeah, it's I'm sure as all of you know, that it's really important that victims understand that they do not have to pay for their sexual assault forensic exam. And we want to tell them right up front that the state of Wisconsin is going to incur the full out-of-pocket costs. And if they do receive a bill, we give them the number in my office, the Office of Crime Victim Services. We give them a 1-800 number that they can call us so we can help them out if that happens. And also under federal law, under the Violence Against Women Act, people are allowed to get a forensic exam whether or not they choose to participate in the criminal justice system, whether or not they cooperate with law enforcement, whether or not they cooperate with prosecution. So we let them know that right away. We also want people to know that the Crime Victims Compensation Program may be able to pay for people's out-of-pocket expenses. To be eligible for that program, we want to let them know that they need to make a report to law enforcement. So this is a little different. In order to qualify for comp, you need to participate with the criminal justice system, you need to make a report within 5 days of the sexual assault, and you need to cooperate fully. But we want to give them all that information right up front.
Yeah, we really wanted victims to know what their rights were up there. But you will note that subpoint B is advocacy services. We could have made other choices, but we wanted to put advocacy services at the very beginning so that it is front and center, because we believe that that's obviously how important it is for victims in the situation that they're in when they present to a medical care facility. So we have B, advocacy services, and we talk a little bit about the factors to be considered when deciding whether to make a report to law enforcement. We talk about a sexual assault advocate, what they can do for you. They can help you with your decision by, and then you can see these subpoints, providing emotional support, talking with you about what may happen after making a report, explaining how the justice system works, helping you to fill out paperwork, locating service agencies, support groups, counseling, and other resources. And then we have a spot here, as you can see, where the local sexual assault advocacy agency would be listed, as well as the phone number. We know that, unfortunately, there are places in our state where there are not advocates who can come to the hospital or can be available to victims all the time when they present at a healthcare facility based on, for example, what time it is or what part of the state you live in. So we put the agency name and phone number right up front there. Then we have a checkbox so that the victim can say, I would like an advocate to follow up with me by phone. We have a spot there for the phone number. We also have a spot for whether it is safe to leave a message and for the advocate to identify themselves when they call this number. We have a spot here also for the email and the information for mail, because we understand from advocates who are on the committee that oftentimes phone numbers can change rapidly, especially after the sexual assault. So we wanted to have a couple lines here where we could collect other information. So after that section, we have a section C, deciding whether to report to law enforcement. As you can imagine, we had a lot of discussion about this, and I don't know if we really talked about it, just how long this process took, but it took, what? Well, we started in 2012, and we're just getting it done now. So it was a lengthy process. There were maybe 30 people at the table at any given meeting. There was a lot of give and take. Let's call it robust discussion, because we had law enforcement, we had advocates, we had prosecutors, and none of those people have strong opinions, let me tell you. So it was a long, I'm kidding. It was, but it was really good, because you get a good product when you test each other, when you talk to each other, when you ask questions, and everybody wanted the same thing. We want the best for victims, and we want to support them in the best way, and we want to catch perpetrators. So there was a lot of discussion about what was the best way to talk about reporting to law enforcement, and you know, sort of the pros and cons, if you will, of that process. So we ended up here with this box under subpoint C that contains two categories. If you report now, law enforcement, and then we just kind of wanted to bullet point. Law enforcement will have the opportunity to interview you about the assault. They will have the opportunity to interview suspects and collect evidence from them. They will have the opportunity to transport the evidence collected from your exam to the state crime lab. They can help you address safety concerns, but they cannot guarantee that your case will result in a criminal charge and conviction. It's hard to strike a balance between what is lost if you don't report to law enforcement and some of the things that are negative, that are difficult about going through the criminal justice system, which we all know, you know, those things happen. So then we have the second box. If you do not report now, crime scene evidence of the sexual assault will not be collected, photographed, or documented and may be permanently lost. Blood and urine specimens will not be collected for forensic analysis to determine whether drugs or alcohol were used to facilitate the sexual assault. That's because we can't do the blood and urine specimen tests later. If the victim decides, you know, later that they want the test, it's too late. Witnesses will not be interviewed in a timely manner, and they may not be available at a later time, and it may be more difficult to successfully prosecute your case. I know that there were advocates in the room, and advocates maybe wanted to see a little bit more at some points of what some of the negative things we're going to do what might be for going through the criminal justice system, but ultimately we decided that articulating those things was somewhat difficult, and we knew that advocates would do a good job talking to victims about that and weighing all those options. So we really felt that that person-to-person contact with the advocate would be key for explaining those issues. 3 questions. Okay. Okay, are kits for minor victims automatically tested?
Yeah, this whole AG SART and what we're going through has nothing to do with anyone with any child victims. This is only in the adult world.
Next question. So the forms given to the victim by the SANE, who gives the SANE the blank forms? I think the question really is that are all hospitals going to use the same form? And yes, the answer is yes, because we are going to include these things hopefully in the administrative regulations that we develop. And we will, I think it's, obviously we anticipate that it'll be a form that's kind of in triplicate almost, so that the hospital keeps a copy, victim keeps a copy. But yes, the answer is they will be provided to the hospitals, and the hospitals will all have the same forms. And then, yes, we believe the SANE nurse is most likely the person who will go through this with the victim. We will provide, and we already are providing training, or the advocate, if the advocate is at the hospital physically. So that's why we're doing training with you all, because we want you all to be equipped to be able to go through these options in this form with the victims, for those of you who are able to do so, which is, of course, fabulous and the best practice under the SART protocol. In those places where that's not possible and the SANE nurse goes through this, we are training the SANE nurses so that they are ready and they are familiar with this information as well. Next question. Are SANE nurses trained to help the victim understand what law enforcement will do and the time frame it takes for conviction or not when making a report? Okay, so yes, SANE nurses will be trained to help the victim understand what law enforcement will and can do. And yes, we do talk to the SANE nurses and we train them and we talk to them about the time frame it takes for a conviction. But I think the crux of what is being asked here is more about some of the negative things about the criminal justice system, right? That it can take a long time. that unfortunately, not, and I'll go you one step further, that the case might not even be charged. Let's talk about that first rather than all getting to a conviction. And, you know, I think the people who are best to address that are advocates, because you are the only people who are there 100% for the victim, regardless of the system. You have no stake in whether this gets reported to the police, whether the prosecutors come. I mean, aside from the stake we all have, which is we want to support victims and hold offenders accountable. But you are there for the victim. You are the best ones to describe this. So we really, yes, we will train SANE nurses because, of course, they have to understand the system. But as you can see by the form, advocates appear, thank you, advocacy services come right up front. Ian?
Hi, Audrey, this is Ian. I just want to re-emphasize or emphasize what Audrey is saying, that while the form has the advocacy services contact information, as Audrey mentioned, there's in no way anticipating that advocates wouldn't be there and perhaps be the ones, as Audrey mentioned, who would be explaining and going through this form. We're just trying to cover all possible options and recognizing that in some places that may not happen, and wanting to ensure that victims get the same information. So I don't want folks to see that, oh, that this is now just, we're just giving advocacy contact information and they're not going to be there. That's certainly not the intent of this.
Yeah, and you know, another good point that Ginger brought up is that community SARTs are really a good place to do cross-training. I mean, your questions are really highlighting how interwoven all the systems are and how we all have to work together, even though we may have different, I mean, you know, of course, law enforcement is going to want to have the case reported to law enforcement. So I know that we all have our own roles that we play, but this is a perfect topic for cross-training through the SARTs and through the local CCRs. So I wanted to put that out there. Next question. Wait, okay, there's a couple questions here. Is this form available in other languages besides English?
Not yet. We can certainly work on that. It's a very good question.
It is a good question.
Right. The smart aleck in me wants to say it took us 3 years to get it done in English.
No.
But no, we will absolutely. It needs to be translated in many languages.
I think what we're really wanting to do now is that there's a huge rollout. So there's a rollout throughout the state, and what we want is your feedback. Would you agree, Jill? This is not set in stone right now.
No, and it's never going to be set in stone. I mean, this is always going to be a dynamic area of work, and we have no reason. You know, I think that we have done what no other state has done with this. Look, what we needed to do was we needed to get rid of this notion that there are anonymous kits, because there is nothing less anonymous than somebody's DNA. And I think that the approach that we took and where we have landed all this puts us miles ahead of any other state and any other jurisdiction. But this is always going to be a work in progress, and we're always going to have to continue to evaluate this, and we're always going to have to continue to modify it.
Okay, Jill, are SANE programs going to be required to work with service providers and volunteer victim advocates?
Are they going to be
required?
Right. You know, certainly there's legislation that that WCASA is pushing to make that part of state law, and it absolutely, you know, I think it's the hope of a lot of us that will become law in this state, and it certainly is something that anybody from the Department of Justice, anybody from WCASA, anyone who is training on this issue is training that is best practice. Okay,
we have another question about minors. Are kits for minor victims automatically tested?
Okay, so I got to say again, this has nothing to do with minor victims. We absolutely want all kits for minors to be tested. It's not part of this protocol. It's not something that AG SART has handled. We are working with places like Wisconsin Children's Hospital to figure out what to do with all of their kits, but it just isn't. It's not on the table for today's discussion, and I don't want us to go down that road. It is something that we need to address, but it just isn't part of this algorithm. It's not part of the information and options. You have all the mandated reporter requirements. Law enforcement has to be involved if there's a child sexual assault. If a report's made to a mandated reporter, and so it's a completely different algorithm.
Okay. I think we're caught up with all the questions. They're all good questions. Thank you so much. No more minor questions. So, okay, thank you. All right, we're on to, wow, okay, so that was all on that, our first goal. Now we're on the goal of revising the sexual assault kit. The order of the collection as numbered in the kits did not match the order that was best for SANE nurse and patient. So what was happening was that the order, when SANE nurses collect do the evidence collection, they have to do so in a specific way, which is dictated essentially by a list that comes in the kit that has to go to the crime lab. The list that was coming from the crime lab was describing for nurses the procedure, and in that described procedure, it would do things like, you know, start down at your feet, but then pluck a hair from your head, and sort of it didn't proceed in the order that SANE nurses would otherwise do their exam. So it just didn't match up. The order that the crime lab wanted nurses to do things in did not match with what SANE nurses thought was best practices on the site. So we changed the order of the collection in the kit, and that was largely based on the goodwill of our friends at the crime lab, who were amazing and who came to the table and said, what can we do to make it better and easier? We also had issues with the transmittal sheet. For those of you who don't know, in every kit that was transmitted to the crime lab, in that big package, I guess you would say, there was a sheet that asked for a lot of information from the SANE nurse, and that sheet was then included with the kit and sent to the crime lab, where the crime lab people would open it up and use the information on that sheet to help them know what to test and what sort of tests to perform where. The unfortunate part was that that sheet included sort of a narrative section with a lot of lines in it that made the SANE nurse write down a narrative of what the victim said had happened. And for those of you who've been through trials with victims who know that any statement the victim makes, when you have multiple statements, when the victim takes the stand, those statements are going to be used against the victim. Oh, why didn't the victim tell you this? Why didn't you write this down? So we got the feedback that a lot of people really wanted that transmittal sheet changed. So we did extensive revisions of the transmittal sheet. Here's another one. The victims' names appeared on the outside of the kit and in many places inside of the kit. And for some of you know that, for example, if a victim was a victim who, at the hands of, say, her husband, who is a police officer, for example, if her name appeared on the outside of that kit and other law enforcement saw it and were transmitting it, they would see that she was the victim. And that was just, it didn't ensure as much confidentiality as we could have had. So the change that we made was to have the victim's name now appear inside on one document. All other places, the name of the victim will be replaced with a barcode. Each one of those barcode stickers will be placed on each piece of evidence inside. The healthcare systems will have the victim's name lined up with the numbers on this barcode, and this barcode sheet will be included in the kit. The healthcare, that leads me to the next subpoint. Healthcare systems used to purchase their kits from different vendors. They would then turn around and charge vastly different sums for them in the billing process. So in order to fix that, and I know I'm going quickly through these things, but these are huge, huge changes. The Wisconsin State Crime Lab agreed to purchase and provide all kits that will be used in the state. So the Department of Justice put out an RFP. They have their own, the kits have been purchased. They are all uniform. They all have the same transmittal sheets. The barcodes then will be unique. so that every kit will now have a unique number and unique barcode numbers included in each kit and provided to the hospitals and healthcare systems throughout the state at no fee.
The next time any of you see Attorney General Brad Schimmel or the Division of Law Enforcement Services Administrator Brian O'Keefe, we owe them a debt of gratitude, because they have agreed from this time forward to pay for every single one of these kits for every single victim in the state. And it's, I don't know of another state that is doing this for certain, and it's, it says a lot about both of their dedication to victims and dedication to this issue.
Yeah, so we're pretty excited about it. Okay, Jill.
Okay. One of the things that we needed to do is we needed to revise the billing practices as they are related to SANE exams. As a lot of you know, in 1994, the Violence Against Women Act required that in order for states to get VAWA funds, they had to make sure that victims were not bearing the full cost for sexual assault medical forensic exams. And in 2005, they required jurisdictions to pay for the full out-of-pocket costs, and they define this as any expense that may be charged to a victim in connection with a medical forensic exam for the purpose of gathering evidence of a sexual assault. And the 2005 provisions contained a provision that not only do we need to pay for victims' exam, but it can no longer be contingent on whether or not a victim is participating in the criminal justice system. That was a big change. And just 2 years ago, in the Reauthorization Act of 2013, the Congress went a little further, and they said no longer can we pay for exams by reimbursing the victims. In other words, we cannot have bills go directly to victims and then pay them back. The bills should go from the medical provider to the government. In 2005, the Wisconsin Sexual Assault Forensic Exam, the SAFE program, was created. And in 2007, the legislature converted the funding in this program from GPR, which is GPR. If you can get GPR funding for anything, you're in very, very good shape, because that's the general purpose revenue. That doesn't go away. But we've got something even better than that for the SAFE fund. We have some sufficient appropriation. That means that we have as much money that we need to pay for these exams. The legislature also, when they enacted the SAFE program, they asked the Department of Justice to promulgate administrative rules to administer the SAFE program. This is just numbers from the past 5 years. In 2010, we did 62 exams. We paid out $51,504. In 2014, we paid for 720 exams, and we paid out $686,878. That's $686,878 that victims did not have to pay, and they were not supposed to see those bills. And of course, I get a lot of questions about this chart, and the question I always get is, oh, so there are a lot more sexual assaults in 2014 than there were in 2010. And I always say, no, that's not what this means at all. It means that we've created a system whereby victims feel a lot more comfortable coming to hospitals and having a SANE exam. They can get treatment. We can get the evidence that we need. And they're willing to do that because we're paying for them. We wouldn't expect, if someone's house got burglarized, we wouldn't expect them to get a bill a couple months later because they had to dust their house for fingerprints. We absolutely should not expect victims of sexual assault to have to pay for their own collection of forensic evidence. One of the things we noticed is that there was just a huge variance in what we were being charged for SANE exams. They range from that dollar sign.
It should really be.
Yeah, sorry about that. Maybe that's like a euro symbol. So they were ranging in price for the exact same exam from $800 to $2,100. And there's a lot of confusion, understandably, about what an examination cost is. So what we wanted to do, because of the uncertainty of the cost and inconsistent billing, is we needed to enact administrative regulations anyhow. We were told to do that when the statute, when 949-20 was passed. And we need rules that specify what examinations, procedures, tests, and medications will be that will be paid for as part of the, quote, exam costs. So that administrative rule has been drafted. The scope statement was approved by the governor's office at the end of last year. We have worked very, very hard at drafting a rule. The week before last, or maybe it was last week, I think it was the week before last, we're at the step of the process where we had to send out a press release telling everyone that DOJ was promulgating this rule, and we're waiting to see if anyone thinks there's going to be any economic impact to wherever they might be in the state. To my knowledge, as of yesterday, I think we talked to Brian the day before. Yesterday, we hadn't gotten any responses. The next step will be then to have sort of an open hearing meeting where people can come in if they have concerns, and then we'll be able to go forward. But we are really, really close to having this rule enacted. Where we are right now is we are going to be able to pay $1,200 for a SANE exam, which is the most of any state in the country. We have a provision in the rule allowing for inflation. We have a provision in the rule allowing for extraordinary costs. We have a very well-defined definition of what costs there are, what a quote examination cost, unquote, will be. And in order to be reimbursed, the hospitals are going to have to spell out exactly what it is they want to be reimbursed for. So victims will know, will have much more information up front about what it is that they will be paid for and what it is that they might have to pay for.
You know, Jill's been really generous in her praise for the other folks that have made a lot of things happen for us, but I do want to take a minute to thank Jill because she has been a tireless advocate for this billing issue. She's just been an incredible, there's a lot of things that had to happen and line up, including some really fun meetings with the Hospital Association and some other folks. So, I don't know. Jill's attempting to hand me a $10 bill right now as if this was a paid promotion, but it's not. All right, we've got some questions. Do rape kits expire? That is a good question. Let me ask this to the questioner. Are you talking about expire meaning they can no longer be tested because the evidence degrades?
I think if your question is to the kits themselves, the bags and the collection tubes and the swabs, you know, I mean, of course, over time, anything is going to disintegrate. The beauty of the system that we're going to have is these are all going to be barcoded. We're going to know where every single one of those kits is. So if we have a situation where we've given a kit out and it's been 10 years and we haven't received that kit back at the crime lab, it's still at a police station, we'd be in a position to say, you know, maybe you should get rid of this number of kits and we're going to resupply you with new ones. As far as, you know, does the evidence in the kits, if you have a kit and you have DNA evidence, what happens if it's sitting somewhere for 6 years? If it's sitting in the right place and it's being preserved as it should be preserved, it should be okay. I mean, you know, does DNA evidence stay on a swab forever? No. But will it stay on there for 6 years? You know, if history is any indication, the answer is absolutely yes.
Yes, the kits themselves, they have an expiration date on them.
Oh, the kit, they have an expiration date.
Are they asking us or telling us?
Asking.
I don't believe they'll have an expiration date on them.
No.
Private healthcare company that was distributing.
Right.
Oh,
yeah.
maybe in the, okay. We have another question. Does the funding cover other injuries sustained during the sexual assault? Yeah, everyone made fun of me over here when I talked about my broken arm, so I'm going to throw this one over to Jill and Ian.
If Audrey had a broken arm and needed an X-ray, which
Jill
I think,
broke my arm.
right, which I think is far more likely than the MRI for her arm, that would not be covered. The forensic exam program pays for the cost of the exam that is performed in the collection of an exam to gather evidence of a sexual assault, and so that would not be covered. That could be covered by the Victims Compensation Program, as long as someone reports in the time frame and cooperates with law enforcement.
Okay, thank you. Okay, we're moving on. So we have now talked about the first work of the AG SART, which was really to tackle the issues faced by victims when they appear and present at a healthcare facility. What happens to them? What happens to the kits? What choices do they have? And what ultimately happens to, in terms of the testing and carrying out that statute number 175. Now we went on to deal with the untested kits issue. You want me to start, or do you want to start?
Okay, so we've got a couple of markers here, and the first marker is what happens before July 1st, 2011, which is when that statute went into effect, and what happens after July 1st, 2011. Clearly, any kit that is collected after July 1st, 2011, if we don't know who the perpetrator is and we have DNA evidence, those kits absolutely have to go to the crime lab. However, we really need to address untested kits that were collected prior to that enactment date of July 1st, 2011. So what we did in May of last year was we sent a survey to every single law enforcement agency in this state, and we asked them to estimate how many untested kits they had in their possession. And we got an amazing response rate. It was 84%. And there are approximately, a little over actually, 6,000 untested kits in the state. And this shows you by county where they are. Not surprisingly, this pretty much goes by population. Milwaukee, Dane, Brown, Kenosha, Outagamie, Winnebago, Rock, Marathon, those are your top ones, and those also are the counties where we have the largest number of people. The little box on the bottom shows you the number of kits that were held at hospitals. We had 163 kits that were held in hospital facilities. It's really important to understand that what we did was just take a snapshot of the state. We wanted to just have a general idea of how many kits we were talking about.
So we had as our goal, we wanted to first understand how many kits there might be out there that were untested. And you can imagine that our friends at the table from the crime lab were very interested in that information because they wanted to know whether how many kits are we talking about out there, and they really didn't have a good idea. Once we got a good idea from that first survey, we started to talk about how are we going to facilitate the processing of these untested kits. So the AG SART undertook as a goal to develop a protocol for submitting the untested evidence kits that were collected prior to the passage of Section 175.405 for analysis at the Wisconsin State Crime Lab. We created a work group of representatives from law enforcement, evidence rooms, SANE nurses, crime lab representatives, and sexual assault victim advocates and prosecutors. And this group developed a protocol for facilitating categorization and prioritization of the kits.
I think that's one thing I want to point out here, that what we did different from other states is what a lot of other states are doing, this thing that they call the forklift approach. And what they do in the forklift approach is they just test any kit they can get their hand on. And we didn't think that was wise for two reasons. It costs between $800 and $1,000 to test every one of these kits. So if there are kits that we didn't need to test for some purpose, for some reason, we didn't want to test those because we want to spend our money where we should be on the kits that need testing. The second thing is that we're really uncertain about what victims have been told about whether or not their kit was going to be tested. We do know for certain that there have been many, many victims who have been told, at no fault of anyone, understandably, that they were going to be able to remain anonymous, or that their evidence wasn't going to be tested, but their kit was just going to be collected. And we wanted to be very, very sensitive to victims and their needs going forward. The first categorization was to look at kits we did not have to test. And we cannot test any kit where there has been a not guilty verdict. Where someone has been acquitted, we cannot test that DNA. The crime lab will use their accreditation if they do test those. Those we will not be testing. The second is we have a statute that went into effect a couple years ago. It's in 968.205 sub 5. And it says that we have to keep any evidence of a case where someone has been convicted, We have to keep that evidence until their sentence is completed. And the idea behind that is if someone wants to appeal their case, you want to be able to allow them to have the DNA that might be relevant and important in their appeal. That's one thing that's important to remember in those 968-205 cases is that because there has been a conviction, that person's DNA has already been submitted to that crime lab and has already been put into CODIS. So we already have their DNA and we already know what crime they committed. So those two categories will not be tested. For the remaining kits, we needed to separate them into those that were collected prior to July 1st, 2011 and after July 1st, 2011.
Oh, this is kind of a, let's not call it an algorithm. It's really more like a flow chart. And this just shows what we've just described. Imagine that you have just a giant, room full of kits, and you have to figure out what to do. What we first wanted to do was make that initial cut where we separate them into, we separate out the kits that are being held under that 968.2055, or if there are kits that are sitting there because there was a not guilty verdict at the trial. You can see the arrow to the right. Those kits are not submitted for testing. Then we take the remaining kits and we separate them into two different piles. I like to think of them as Rubbermaid tubs kind of in my brain. So we put some kits, the kits that were collected before July 1st, 2011, into one tub, and then we put the kits collected after July 1st, 2011 into the other tub. Question then becomes, what do we do with these two categories?
So we need to figure out a number of things. 175-405 requires us to figure out if the perp has been identified or unidentified. We want to be extremely sensitive to victims. So is this a case where a victim has participated with law enforcement, or is it a case where a victim has chosen not to participate in the criminal justice system? Where is the case in the system? Has the case been charged by the DA? And where are we as far as the statute of limitations is concerned? The last two, whether or not a case has been charged in the statute of limitations, those are time is of the essence questions. Audrey and I have talked a lot about how every single night we go to bed, we think, oh my God, that's one more day where a statute of limitations has passed for somebody. So we have sent a second survey to law enforcement, and we've asked them, now that we know that we have these, a little over 6,100 kits, can you please put them into the categories and the subcategories for us? Because what we want to do next is to figure out how many we have in each section, because we've come up with a way to triage these for the crime lab, so that the crime lab can test the kits we think need to be tested first, and the kits that are able to wait a little while, they'll test those last. I just want to note that that's also a different approach than many other jurisdictions have taken. A lot of jurisdictions have taken, they're going to test the oldest ones first, and I question how wise that decision is, because the oldest ones that are outside the statute of limitations are already outside the statute of limitations, and you're not running up against a clock. And before finalizing any kind of matrix, we really wanted to think about, what does the victim want in this individual case?
And this kind of touches on that lack of uniformity that we talked about a little bit at the beginning. It's really unclear what victims were told when their kits were collected in the past. Were the victims told that all the kits would be tested? Many people come to us and advocates and tell us that there is an assumption by many victims that, if you're collecting this evidence and putting it into a kit, it's going to be tested. And that is not always true, as we know. Was the victim told that the kit would not be tested without their consent? Like, oh, we're collecting the kit and we're not going to send it for testing unless and until we hear from you. Were the victims told that the kit would only be tested if a report was made to law enforcement? Or were they told that the kit would be tested even if they didn't make a report to law enforcement? It's really unclear.
And none of anything that was told to a victim, it's at no fault of whoever was giving them that information. We just were not consistent across the state.
So given that we don't know what victims were told about the processing of their kits, we faced several additional challenges when we were trying to figure out what's the best thing to do with these untested kits. If we tested without telling the victims, this might violate their trust. especially if the victim was told that such testing would not happen. Because each hospital system and each law enforcement system and everybody was doing things a little bit differently, we don't want to have the victim's trust violated. We also know that recontacting victims many years after the incident can trigger the trauma response. Victims have gone on with their lives in many cases, and they don't expect somebody to come knocking on their door and ask them about an incident that's happened many years ago. We also know that testing kits would necessarily identify the victim's DNA profile, which could have negative repercussions. For example, if there was a warrant out for that victim based on their DNA from some sort of crime scene, and the victim's DNA is suddenly run through the system, it might connect up to that warrant. We also knew, like I said, that some victims' expectations might be that the kit has already been tested. So given these, I guess, these issues, these concerns that we had about not violating victims' trust, the AG SART group concluded that there should be outreach to victims throughout the state. You want to talk about Texas maybe, or how we came up with that idea? Ian, maybe?
Sure. As you can imagine, this is, and has already been said, this is not, Wisconsin is not alone in facing the problem of untested rape kits. There's been widespread media coverage of this, and so, you know, other states have looked, and other jurisdictions have looked at this problem. You know, Houston, Detroit, Los Angeles are some of the places you may have heard about, and they've adopted a variety of approaches. One thing that the city of Houston did, and they've released some documents, reports of their findings of their work. Now, again, difference between a city and a whole state, but I think Houston had 10,000 or a huge number just in that city. What's that? Bigger than two Wisconsins, right? So they, you know, used a sort of a PSA approach, public service announcement, as part of their notification to try and get the word out about that there's an effort to look at untested rape kits and to give survivors an option of finding out more, allowing for survivors to opt in rather than make that decision for them. And so that's something that we are looking at here in Wisconsin. We know that PSAs don't just happen. They have to be created, and that costs money. And so that's something that, I don't know if you want to talk about the grant application.
Yeah, so we have, at the Department of Justice, we actually have submitted applications for 2 grants. One is through the District Attorney's Office in Manhattan, New York, and the other is through the federal government. The one that we applied for with the feds would give us money, and we specifically asked for money for WCASA to be able to do PSAs around the state. And we're really, really hoping that because we already had an AG SART set up, that will be a very, very good candidate for getting some of this money.
So ultimately, I think it's safe to say that the victim consent issue was such an important piece that we had kits collected before July 1st, 2011. We've basically started from the assumption that those will not be analyzed unless the victim reported to law enforcement or comes forward as a result of the public service announcement and gives consent for his or her kit to be tested. Oh boy.
So what we needed to do is we needed to figure out how we were going to triage, how we were going to prioritize which kits we needed to test first. And what we needed to do, the first thing we did was we looked at where is time of the essence? Where is the clock ticking? And where the clock is ticking is for any case before July 1st, 2011 is, if you look in the bottom in chart number 2, is where there is a case in a DA's office and that case is pending. Those cases have a huge priority, and the reason is this. Those cases are going to come to resolution sometime soon, within months more than likely. If we do not get that DNA lift up into CODIS and there's an acquittal or something, or a mistrial or something, we will miss an opportunity to have loaded that DNA into CODIS. And we want to do that before we lose the opportunity to load it. The other case where we have the first priority is in chart number 1, where we are within the statute of limitations, but the DA has decided not to process it, or law enforcement never forwarded it to the DA's office, and the victim reported to law enforcement. In these cases, the perpetrator has not been identified. These are stranger assaults. We still could be able to prosecute them, and the victim wants to be involved. And in those cases, we want to get those to the crime lab as soon as we can. Where we get to the, I don't think there's any first priorities in the next chart, is there? Yeah, oh, yeah, sorry. Again, if you look in chart number 4, a priority 1 is where a case has been charged in the DA's office. This is, the red is after July 1st, 2011. And the, in chart number 3, the last part of our first priority, these are cases that are after this law went into effect, the perpetrator has not been identified, and the victim reported to law enforcement. Those under the statute must be sent to the crime lab, and we put a priority on them because this is a victim who wants to be part of the system, and there is an unidentified perpetrator out there. I can't imagine anything scarier. So we want to get those kids tested immediately.
Go back.
Okay. When we're talking about what's kind of in our second category as far as priorities are concerned, in chart number 1, these are before July 1st, 2011 category. We have not identified the perpetrator, and there hasn't been a report to law enforcement. In these cases, it says test with victim consent, priority number 2. The victim consent will come from the PSAs that Ian was just talking about. In the chart underneath that, it's, we do know who the perpetrator is. The victim is participating with law enforcement. We're within the statute of limitations, so we want to figure out who this is before the statute of limitation runs. That case has not been submitted to a DA and has not, or has never been referred to law enforcement. This category right here, chart number 2, victim reported to law enforcement within the statute of limitations. This, I think, is going to be our highest number of cases. This is where the victim knows the perpetrator, and law enforcement has said, well, the victim knows the perpetrator, so we don't really need to do anything about the DNA because we know who this person is. And if I had $1 for every time I've been asked, why do we have to forward these to the crime lab, I'd be able to pay Audrey off for the rest of my life to say really, really nice things about me every day. And this is the example that we are giving. What we know is 2 things about sexual assault perpetrators. Number 1, they're generally serial perpetrators. And number 2, they're more likely to perpetrate a sexual assault against somebody they know. If you have a sexual assault and the victim knows the perpetrator, and that victim has a SANE kit, and law enforcement get involved, and law enforcement says, wait, we don't need to send this to the crime lab. It doesn't need to be uploaded into CODIS. We know who the perpetrator is. And that perpetrator goes up in the next week or 2 and commits a similar sexual assault against someone he knows in Marathon County, and the Marathon County law enforcement officer says the same thing. We'll never have an opportunity to connect those 2 dots. But if we do upload, get that DNA to the crime lab and upload both of those into the CODIS system, we're going to be able to connect those dots, and how much stronger do those individual cases get? So that's why we want to test those kits. In the box above that, the perpetrator hasn't been identified. We're before July 1st, 2011. I'm sorry. I got to move over. I've done all the priority 2s in this box. For the priority 3s, we're outside the statute of limitations. So these are situations where the statute has run. We're not going to be able to use this evidence in this particular case, but we might be able to use it for other acts evidence. We might be able to use it in sentencing. It doesn't, all is not lost. This still could be very, very valuable evidence. And the one where it says test with victim consent in chart number 1, that again is because that victim had decided that they didn't want to participate in the law enforcement system, and we're not going to test these kits if we're not sure that a victim who previously didn't want to report, we want to make sure that they do want to report now. Oops, no, go back.
Oh, Nellie.
Oh.
They do now.
You go.
Oh.
You're pressing the wrong button. Okay, stop, stop. Okay, two more. If we are after July, what'd you say? Okay, we're on chart number 3 here. If it is after July 1st, 2011, if there's been a no pros or not a referral, and there has not been a report to law enforcement, these kits are going to be in our second priority. Again, this is a little difficult for a lot of us because we so want victims to be part of this, but this is, unfortunately for these victims, they have not been participating in the criminal justice system, but the statute tells us that we need to get their kits tested. You know, I'm hoping that we're going to be able to do outreach and let them know what's going on, because I think that that is only fair to these people, but the statute mandates the testing of these kits. After July 1st, if a perpetrator has been identified and the victim is reporting to law enforcement, we want those kits tested. If a victim is willing to come forward, whether or not a perpetrator has been identified, whether or not this is before or after July 1st, 2011, if a victim is willing to participate in the criminal justice system, we want those kits tested.
Hi again, this is Ian. And this matrix, I know probably you are seeing for this for the first time, and for those of us who went through the process, I mean, it's complicated, and so yeah, I hopefully, and this is not your only opportunity to ask questions, and feel free to ask questions now. You know how to reach. Hopefully, you all know how to reach me. We can send out my contact information, maybe send out Ginger's contact information because she's participated in this as well. For questions, we'd be happy to talk to you more about that. But I think what the point Jill just made about the law change in July 1st of 2011 and the fact that those kits that are collected after that there are some where we're going to have to test whether or not the victim consented. The reason why, I'm going back to the algorithm, that's why that option 3 is so important, so that we're not going to have this situation going forward.
Right.
Because option 3 says, right, the victim is unsure, the kit is collected, and that's why it goes from hospital directly to the crime lab. So that it's not tested, because if it went to law enforcement, we could be in that situation of it's got to be tested. So that's why, again, going back to that algorithm, we were very intentional about creating that option 3 so that we wouldn't have this situation prospectively.
Thanks, Ian. Yeah, this all folds together. Oh, get off this slide, please.
Okay. Okay.
Okay.
Right.
After we categorize these and prioritize them, then they'll go to the state crime lab and be assigned based on the prioritization. And of course, it's not going to be all neat and clean. Going forward, 175.405 is going to govern which forensic kits will be sent to the crime lab for analysis. We're also going to have administrative rules so that we can make sure that, like I said, in the cases where a victim wants to be engaged in the criminal justice system, we can make sure those kits are tested. What's next for the AG SART?
Some might ask.
Right.
Well, we've identified some challenges that we think ought to be addressed, and I should say that we are again thankful to the Attorney General, Brad Schimmel, because there was a real prospect that once we did all this work on these issues and sort of completed our charts and algorithms and matrices and all the things that we've done, that you could just say, okay, thanks for doing your job, thanks, job well done, see you later. But Attorney General Schimmel is keenly interested. He actually attends the meetings of the AG SART, and he is so supportive of the work and wants the AG SART to continue. We have identified some challenges that need to be addressed. Here's a couple of them. Sustainability of SANE programs throughout the state. Availability of SANE exams, because we know there are many counties where there are not SANE exams available, and victims are having to travel many miles in order to get SANE exams. We are also tackling the issue of college campus sexual assaults. which I've been in the media of late, and everybody I know understands the complex issues associated with that. Here we go.
Where's your contact information?
I guess you have to pay me another $10 for that. So the contact information, we have Jill Karofsky up there. I suppose you could call me, sure, but Jill's so knowledgeable. Send her an email or a phone call. She's got her number up there. I kid you, I will send out my information as well. Ian also has participated in all of the AG SART meetings, so he is another resource for you. You could contact Ian. And at this point, I'm looking. I don't see any additional questions, but we're certainly open for questions. Okay, let's see.
We will be sending out a copy of the slides either this afternoon or early next week.
Okay. I just want to say in closing that putting a PowerPoint together that sums up 3 years of work like this is a monumental task, and Audrey did this pretty much the whole thing. I think I added a picture to one of the slides.
That's true.
It took a lot of work to summarize all these various facets and to be able to do it in a way that was explainable to people who hadn't been part of the process. And Audrey and I have been sharing the AG SART since it started, and it's been a lot of work, but Audrey's really pulled us through a lot of challenging times. There are also just a lot of great advocates who have given their time and energy to the AG SART, and without their commitment, I just think of all the times that Vicki Bean would make a point and then not let me get to the bathroom until she made it several more times. She was just awesome. So we very much appreciate your input and your expertise, and thank you for your devotion and your dedication every single day.
We do have one more question. I just want to say here, and I second that, what Jill said. Thank you so much for everything that you all do. We've got one more question. It says, how will hospitals be notified of the process changes for the kits?
That's a good question. Also on the AG SART, we've had hospital systems. We've had representatives from Mercy, Meritor, Ministry, and we've got SANE nurses from Aurora, and we're in touch with Aurora. But through the SANE programs and through the SANE nurses and through those bigger hospital systems that have worked with us, we're going to get the word out through them. We
also have the SANE training program is now in the Department of Justice. So I know there's a website there. There are continuing trainings, and we are doing this very rollout with all this information for SANE nurses around the state, and we will be doing that for the next year, I would say.
All right. Thanks to WCASA for letting us do this.
Thank you. Thanks for having us to your house.
Have a great rest of your day.